MOOC on democratic awareness with legal literacy. Welcome to the class. Today's topic is contempt of court. If justice is administered in accordance with the law enacted by the legislature, it is the duty of the administration to implement the order passed by the court. If the administration does not implement the order passed by the court, then ultimately people for whom the order is passed will not get the benefit of the law. Law will remain only in the statute book, just like a ritual. And if democracy is to be vibrant and meaningful to the common people, then the independence of the judiciary must be protected, which is done in every democracy, in every democratic country of the world. Now, this power for contempt of court is given to the judiciary, particularly the higher echelons of the judiciary, so that the order passed by the court is implemented and the majesty of law is protected. And this power is exercised not for the individual, not for protection of the individual judges. This is for the function, for protection of the function which the judges exercise. Let us see two quotations from two eminent jurists of the world. First quotation is, this is a quotation from a judgment delivered by Justice Felix Frankfurter, who was judge of US Supreme Court for long 23 years. He had said, the power to punish for contempt of court is a safeguard not for judges as persons, but for the function which they exercise. The similar view is expressed by another eminent jurist, Lord Denning, in his book Due Process of Law. He had said, the course of justice must not be deflected or interfered with. Those who strike at it strike at the very foundation of our society. To maintain law and order, the judges have and must have power at once to deal with those who offend against it. It is a great power, a power instantly to imprison a person without trial, but it is a necessary power. So, the procedure for contempt of court is not like a trial of a criminal court. The judge who has passed the order, who is issuing the contempt rule, can impose punishment only after giving an opportunity of hearing to the person who is liable for contempt of court. Similarly, if a criminal contempt is made out, then to protect the independence of the judiciary or for protection of the majesty of law, the person will be held liable only after giving an opportunity of hearing, not a regular trial. After that, punishment can be imposed. So, let us see what is meant by contempt of court. Contempt of court has two divisions. One is civil contempt, another is criminal contempt. What is civil contempt? Civil contempt means willful disobedience to any judgment, decree, direction, order, writ or other process of a court or willful breach of an undertaking given by a court. So, any order which is passed by the court, if that order is violated by anyone intentionally or willfully, then that amounts to civil contempt. If a person gives an undertaking before the court and on the basis of that undertaking court has passed the order, subsequently if that person backs out and violates the order, then he is also liable for civil contempt. Generally, the parties to the proceeding are liable for civil contempt, but a third party, if the third party aids or abets violation of the order intentionally or willfully, then that third party also will be liable for civil contempt. Now, this is the ambit of civil contempt, but the ambit of criminal contempt is wider than the civil contempt. What is criminal contempt? Criminal contempt means the publication of any matter, it may be in writing, may be orally, or may be by any visible representation. So, if any matter is communicated to another which scandalizes or lowers down the authority of the court in the eye of public, or which prejudices or interferes with the course of any judicial proceeding, or interferes or obstructs administration of justice, then that amounts to criminal contempt. So, if anyone by orally or by in writing or by any visible representation communicates to another person something which lowers down the authority of the court in the eye of public, or obstructs the administration of justice, or interferes with the course of judicial proceeding, or that has a tendency to interfere with the course of judicial proceeding, or tendency to obstruct administration of justice, or scandalizes the judiciary, then that amounts to criminal contempt. What is the punishment? And what is the source? What is the source of this power of contempt of court? The Constitution has given this power of contempt of court to the High Court and the Supreme Court. The High Court can exercise the power of contempt of court under Article 215 of the Constitution as a court of record. Similarly, the Supreme Court can exercise the power of contempt of itself as a court of record. This power is given under Article 129 and 142 of the Constitution of India. So, the Supreme Court and the High Court can exercise this power of contempt of court as a court of record. What is court of record? That is not defined in the Constitution, that is not defined in any other law. But we can understand from various judicial pronouncement that if two conditions are fulfilled, then a court can be called a court of record. What are those two conditions? First, the court which has the power and authority to decide about its own procedure for exercise of its jurisdiction. Secondly, the court which has the power to punish for its own contempt. If these two conditions are fulfilled, then that court is a court of record. The High Court is a court of record, the Supreme Court is a court of record. When the Constitution did not come into existence in the year 1883, Sir Surendranath Banerjee, a great patriot, was held liable for committing criminal contempt by the High Court of Judicature at Fort William for writing one contemptuous article in his weekly periodical. He was held liable, he was asked to tender apology, he refused to tender apology, and then he was sentenced to imprisonment, perhaps for 3 months, and he suffered that imprisonment. This power was exercised by the High Court of Judicature at Fort William in the year 1883 as a court of record. At that time, there was no constitution, there was no law of contempt of court. Now, the legislature has enacted the present law is Contempt of Court Act of 1971. Now, this Contempt of Court Act has prescribed punishment for both civil contempt and criminal contempt. Now, there is no difference between civil contempt and criminal contempt with regard to the quantum of punishment. For both civil contempt and criminal contempt, punishment is maximum 6 months imprisonment and fine of rupees 2000 or both. So, the Supreme Court and the High Court is given the power to punish for its own contempt as a court of record by the Constitution. But the Contempt of Court Act of 1971 has given power and authority to the High Court for contempt of subordinate courts. Under section 10 of the Contempt of Court Act, the High Court can exercise the power for contempt of the subordinate court. Apart from that, any private individual can initiate a proceeding for criminal contempt before a High Court with written consent of the Advocate General. Advocate General also can start a criminal contempt before High Court. The High Court can also start criminal contempt suo motu. The subordinate court or the district judiciary can also refer to the High Court for drawing up any contempt proceeding against anyone who has committed criminal contempt. So, the procedure for invoking contempt of court by a common man, if it is a criminal contempt, it can be done only with consent in writing of the Advocate General. And a party who has got an order from the court and that order is violated by anyone, then or that order is not implemented by the state agency, in that case, that party can invoke the power of contempt of court of the High Court or the Supreme Court for implementation of the order. The district judiciary is not given the power of contempt of court either under the Constitution or under the Contempt of Courts Act 1971. But limited power of contempt is also given to the district judiciary. That means the civil court, revenue court or the criminal court under section 345 of the Code of Criminal Procedure 1973. Under this provision, the presiding officer of any civil court, criminal court or revenue court can impose punishment of fine of 200 rupees in default of payment of fine to give a sentence of 1 month imprisonment. Under what circumstances this can be done? If the presiding officer of the court in the midst of hearing of any judicial proceeding finds that anyone refuses to produce any document in pursuance of the summons issued by the court, or if anyone refuses to take oath, or if anyone refuses to sign on the statement given by him, or if anyone interrupts the judicial proceeding, or if anyone insults the presiding officer of the court, then the presiding officer of the court can invoke this power and after giving an opportunity of hearing impose a fine of 200 rupees, and in default of payment of fine the person can be sent to the correctional home for 1 month. Now, this power is given to the civil court, criminal court and revenue court so that the court can maintain the presiding officer of the court can maintain the dignity of the court and can proceed with the judicial proceeding uninterruptedly. Now, I will cite a few cases on contempt of court. The first one is Delhi Judicial Service Association versus State of Gujarat. In this case, one Chief Judicial Magistrate of Nadiad in Gujarat, he was invited to the local police station and then he was detained in the police station. He was forced to consume liquor and he was not allowed to talk with anyone of his family members, anyone of the district judiciary, and on the next day he was handcuffed and produced before the district hospital for medical examination. This incident was reported to the High Court by filing a writ petition, and the High Court, through one sitting judge of another High Court, conducted an inquiry, and it was established from the inquiry that the Superintendent of Police and the SHO of the police station and some police officials, they hatched a conspiracy, called the Chief Judicial Magistrate, so that the Chief Judicial Magistrate can be implicated in a criminal case and he can be bowed down. So that because he was in the habit of passing strictures against the police for non-compliance of the order of the court. In this case, the Supreme Court invoked the power of contempt of court, and Supreme Court imposed punishment of 1 month imprisonment on the Superintendent of Police and 3 months imprisonment on other police officers. Why the Supreme Court invoked the power of contempt of court? Because according to the Supreme Court, this insult is not to an individual judicial officer, but it was affront to the entire district judiciary. If the police can humiliate one judge or judicial officer on flimsy pretext, on false by making false allegation, then the independence of the judiciary will vanish. So, judges will not be able to discharge their duty impartially and independently. Now, another case is M.V. Jayarajan versus High Court of Kerala. In this case, the Jayaraman is an advocate. The division bench of Kerala High Court passed an order that no one will be allowed to hold any public meeting on a public road in a working day. This order of the High Court was subsequently affirmed by the Supreme Court, and this advocate, who was also a leader of a political party, in a public meeting criticized the judgment and the judges who passed this judgment by using pejorative language. And he asked the people who were present in the meeting to violate this order. Then he was held up for contempt of court. The advocate took the plea that he has freedom of speech and expression, he can do that. He preferred an appeal. The High Court held him for contempt of court and imposed sentence of 6 months imprisonment on him. Then he preferred an appeal. The Supreme Court reduced the sentence from 6 months to 6 weeks, the advocate tendered apology at the belated stage, but the Supreme Court did not accept the apology. So, apology can be tendered in a criminal contempt if the contemner is committing the contempt for the first time and if he purges of the contempt by his conduct. Then in that situation, the court will not impose any punishment. And in a civil contempt, if the contemner can comply with the order or direction given by the court, then also the court will not impose any sentence on the contemner. Now, the next case is Secretary of Hailakandi Bar Association versus State of Assam. In this case, one person was arrested on the allegation of committing dacoity. He was detained illegally in the custody without producing before the court of the magistrate, and then he was mercilessly beaten up. He was not allowed to meet with his family members, and on the third day of illegal detention, he was produced before the court of the magistrate. Then the magistrate refused to give police custody. He was sent to the correctional home, but on the fourth day, he died in the hospital of the correctional home. And then a postmortem report was conducted, and the family members of the victim refused to accept the dead body. They filed an application before the court of Chief Judicial Magistrate for conducting second postmortem examination by a team of doctors in a medical college. This incident was recorded by the Bar Association of Hailakandi, and it was reported to the Supreme Court. The Supreme Court treated it as a writ petition, and contempt, and an inquiry was held by CBI, and it was found from the report of inquiry that the Superintendent of Police filed one affidavit in the Supreme Court in order to protect the misdeeds of the subordinate. So, a false report was submitted, supported by an affidavit, which was detected by the Supreme Court, and the Supreme Court held the Superintendent of Police liable for contempt of court because the Superintendent of Police obstructed the administration of justice by filing false affidavit. So, he was sentenced to imprisonment for 1 month. Another case is Mahipal Singh Rana versus State of UP. This is a case where Civil Judge Senior Division in the district of Etwa in UP, he was conducting a case. In the midst of hearing of that case, Mahipal Singh Rana, who was a practicing advocate of that court, he interrupted the judicial proceeding, and he asked the judge why his case was not given priority of hearing, and why the order which he wanted was not passed. So, this incident was repeated on 2 occasions on 2 different dates. The judge, the Civil Judge Senior Division, recorded the proceedings, and the matter was referred to the High Court for drawing up of criminal contempt proceeding against that advocate. The High Court issued contempt rule. Mahipal Singh Rana appeared before the High Court, but his view was not accepted. He was held up for contempt of court, and he was not only sentenced to imprisonment, but he was prohibited from appearing in the courts of judgeship of Etwa unless he purges of the contempt. He preferred an appeal before the Supreme Court. The Supreme Court also held the same thing. The Supreme Court also sentenced him to imprisonment, perhaps for 6 weeks, but his license to practice as an advocate was suspended for 5 years, and he was debarred from appearing before the courts in the judgeship of Etwa unless he purges of the contempt by his conduct. The Supreme Court has clarified in this case that the Supreme Court can pass order for suspending the license of an advocate as an appellate authority of the Bar Council of India under section 38 of the Advocates Act of 1961, and the same order can be passed by the High Court by way of judicial review under Article 226 of the Constitution. The Supreme Court has said in this case that only because an advocate has the license to practice as a lawyer or an advocate, and that license is granted by the Bar Council, that does not mean that the advocate who is committing criminal contempt has the authority to appear before the court if the court imposes a prohibition from appearing before the court on the contemner who is liable for criminal contempt. The advocate can practice without appearing before the court by giving advice to the client, by drafting the pleading and by drafting the conveyances. Without appearing before the court, an advocate can continue the practice, but appearance before the court will be regulated by the court, by the judiciary, and that is the view, that is the law laid down by the Supreme Court in this case. So, if any advocate commits criminal contempt, he can be debarred from appearing before the court unless he purges himself of the contempt by his conduct. Purging means if he is genuinely regrets for what he has done. Otherwise, he will not be permitted to appear before the court. So, that is the law laid down by the Supreme Court, in this case Mahipal Singh Rana versus State of UP. This country is to be governed by rule of law. If the democracy is to be vibrant and meaningful to the common people, and that can be done only by implementation of the order or judgment passed by the judiciary. If that is not done, then the people will not be able to enjoy the right which is protected under the law. And if the judiciary is not allowed to use the power of contempt of court, particularly the higher echelons of the judiciary in our country, High Court and the Supreme Court, if they do not have the power to punish for contempt of court, then the order passed by the High Court and the Supreme Court will not be implemented by the administration. So, this power is a necessary power. This power is necessary for protection of the function which the judiciary or the judges exercise. Now, fair criticism of the judgment is not contempt. Anyone has the right to criticize the judgment without attributing any motive to the judge. Any complaint which is made by a person against a member of district judiciary before the High Court does not amount to contempt. Any reporting of any judicial proceeding in the media, in the print media or electronic media, in the social media, does not amount to contempt. So, anyone can enjoy the freedom of speech and expression without doing anything which will lower down the authority of the court in the eye of public, which will obstruct the course of justice, or which will amount to interference with the administration of justice. So, that is the object of giving the power of contempt of court to the High Court and the Supreme Court, and even the district judiciary has the limited power of contempt, as I have pointed out under section 345 of the Code of Criminal Procedure, for maintaining the dignity of the judiciary and for continuation of the judicial proceedings in a dignified manner.